Mr. Mob, you were done with leading your witness, isn't it?
Indeed, Justice Jafta completed the examination in chief. Thank you, sir.
All right, thank you. Judge Malindi, are you ready to start your cross-examination?
Thank you very much, President. We are ready. Judge President, may I refer to page 1 of the bundle of documents, which I hope are before you, not your bundle, the main bundle.
The main bundle, okay.
And page 1 contains your affidavit in support of the complaint. As you can see from the second paragraph, starting, I refer to a complaint referral letter. That complaint referral letter was on 14 May 2020, is that correct?
Yeah, correct, yes.
And then after the commission received this letter, you were advised to support the complaint in an affidavit form, which was then delivered on 16 October 2020.
Yes.
At the time of your letter of 14 May 2020, you were referring to 4 judgments that are in the middle of the page.
Yes.
Yes. And by the time you submitted the affidavit in October 2020, there were an additional 6 outstanding judgments which you place as of 14 September 2020. That is the paragraph just below case number 4 in the middle of the page.
Which page are you at, Judge Malindi?
Still page 1.
Oh, okay, yes.
And then on page 2, in the paragraph starting, I further highlight the following matters in which judgment was handed down, but only after an unreasonable time had passed. I understand that to mean that by the time you submitted the affidavit, those judgments had been handed down on the dates that appear in relation to each of the 10 matters below that paragraph.
Yes.
And then in the paragraph below the 10th case listed thereunder, you say the following: it appears to be an unfortunate norm for litigants to wait an extraordinary time for the judgments in their matters before Judge N Mngqibisa-Thusi. And so the 10 judgments above this paragraph were listed only to illustrate a pattern of delays in delivery of judgments by Judge Mngqibisa-Thusi.
Yes.
And then in your letter of requesting suspension of Judge Mngqibisa, which appears on page 38 of the record, you say at paragraph 8 on page 40, it is clear to me that retaining Judge Mngqibisa-Thusi on the roll would be ill-advised and will simply expose litigants to further hardships as a consequence of them being kept waiting for their judgments for inordinate periods of time. I therefore submit that it is in the best interests of litigants and the image and reputation of the judiciary that the President be advised to suspend her. I've edited the paragraph.
Yes.
Yes. In your evidence this morning, Judge President, I was not sure whether you characterize Judge Mngqibisa-Thusi's conduct as gross misconduct for her failure to respond to your inquiries when you did about outstanding judgments, or whether the gross misconduct is the delayed judgments per se. Could you clarify that for me?
It's the delayed judgments, per se.
The delayed judgments per se.
So I didn't hear that.
The delayed judgments, per se.
As I understand your evidence, you do not question that Judge Mngqibisa-Thusi was afflicted, to use that word, by the conditions that are set out in the two expert reports.
I didn't get what you said, please.
In your evidence,
Yes.
I got the impression that you do not dispute that Judge Mngqibisa-Thusi was afflicted or suffered the conditions set out in the two expert reports.
No, I'm in no position to dispute that.
If those conditions resulted in her not being able to deliver judgments and perform as she had done for many years before then, she would not be guilty of gross misconduct because it would have been because of those conditions that she was unable to deliver.
Well, can I explain the following, if it's okay? Yes, she, as I said, I don't dispute that. As her experts say, she was afflicted in their reports. But my point as head of court is, if you have a situation like that, that's stopping you from working, it's your responsibility to ensure that you give the powers that be an indication that you have a problem. You are unable to work because of something, so that you can be assisted to make sure that you deal with that problem for you to be able to do your work.
Indeed, you testified at length in your discussion with Mr. Mop about your leadership style and which would be followed by the JSC processes if there has been no cooperation with you in the processes that you follow before you lay a complaint.
Yes.
When the norms and standards were being deliberated on and the JSC process was agreed, was there a suggestion or discussion on formalizing the pre-JSC complaint process?
At which discussion? You've lost me, Judge Malindi. I don't know what you're talking about now.
You testified, JP, that you were part of the drafting of the norms and standards.
Yes.
And led by Chief Justice Mngqibisa-Thusi.
Yes.
Yes. In those discussions, was there a discussion on a formal process to be followed by heads of court before they complained to the JSC?
I don't recall that there was such a discussion. No.
Yes. Are you agreeable, as is suggested by Gogo Machiki, that a formalized process will benefit judges who otherwise will be reticent to approaching you personally, directly on their problems?
I think we're talking about two things. You're talking about formalizing a JSC process in the context of the discussion of the norms and standards. You're now mentioning what Gogo Machiki says there should be, I think, a policy framework to assist persons who would be equally afflicted. Those are two different things. But what I understand, and having been a head of court for more than 10 years, is judges are not children. They know what their responsibility is. And when there are issues that affect them in the performance of their work, it is their responsibility to ensure that they activate processes that will assist them. I'm not sure that one can take refuge behind the fact that there's no written, formalized process that deals with this.
If there was a subcommittee to which judges could go when they have problems of the nature that Judge Mngqibisa-Thusi has, or any other problem that prevents them from delivering judgments in accordance with the norms and standards, would that assist as a pre-complaint process?
There's no subcommittee in the judiciary as we speak, and has never been, where judges could forward anything. Everything is dealt with in the context of the courts they are in. So I'm not sure I agree that if there was a subcommittee of sorts that takes, that listens to issues from judges nationally and deals with those things that the judges raise, I'm not sure if that will work, because our responsibilities as heads of courts are clear, that you lead your division, you attend to everything that comes out of your division. If judges have issues, I don't see any reason why they should go out of the division to seek assistance for their issues that affect their work in the division. I don't see any sense in that, I must say.
but you would agree, JP, that judges as colleagues would have colleagues to whom they could easily confide on their problems more than they would with any other judges, and including the JP of the division.
Yes, I mean, Judge Mngqibisa-Thusi was big friends with Judge Matojane, you know. I mean, I think they were appointed at the same time. So I recognize those relationships divisionally. But there's a reason why you've got formalized structures divisionally, like the judges' meetings, where a judge will be able to raise any issue that's of particular concern to him or her in that forum. Because you are in this division, this is what troubling you in the division. I would say, unless there's something that is a problem between the particular judge and the head of court that forces that judge to not want to talk to that head of court, I don't see any reason why a judge should want to go outside his or her division to find a solution for his or her problems.
So, on that premise, JP, it would make sense for Judge Mngqibisa-Thusi to discuss a subject or subjects that are covered in the 2 expert witness reports with her closest friends if she doesn't know how you would receive such a disclosure.
If her quest is to have those closest judicial colleagues to help her talk to the JP, because if the discussion is just with them and it ends there, it will achieve nothing. Because those colleagues that she talks to have no powers to initiate anything that could assist her. I think that's why I said in my evidence, she thanks the acting DJPs for speaking to them. I don't know whether she shared with them what her afflictions were or what her problems were. But I would have expected that if she speaks to them, it was for them to say, hey, please go to the JP. I don't want to, or I'm unable to, or I feel reticent in talking to him. Go to him, tell him, alert him, I have these problems and I need assistance.
And as a judge who's practiced in many levels of the judiciary and a leader of the judiciary, you would appreciate that certain matters which bring shame, embarrassment, it's not easy for certain people to discuss them even with their leaders in any institution.
I'm sure there would be such matters, but I don't think one can allow such matters to allow the work of the division to suffer.
Yes.
I think that's my standpoint. And Judge Malindi, I've had all sorts of communications with me. You say shame, even worse than that, which I can't disclose, but I've had them with colleagues because they want me to understand what they are going through. And they are saying to me, can you help? And I want to believe in all those instances I've helped.
And now some individuals may decide, if at the risk of repeating myself, that those matters are of such a nature that they can discuss them with the closest of colleagues and not do so with the head of court, and that should still be reasonable, because it's a matter that will bring shame, or it's a matter that stigmatizes people if they are known to have a condition such as is discussed in the reports.
Look, any discussion can happen with whoever you trust, Judge Malindi, but let's not divorce that discussion with the overall context in which that discussion is happening. It's happening because it's interfering with work performance.
Yes.
If that discussion will lead to a resolution of that, fine. And I don't know, I think I want to take issue with this shame issue. I mean, Judge Mngqibisa in his ruling doesn't regard it as something that's shameful. It's not. It's us, Africans, isn't it? So I don't understand where the shame part comes in, and especially when it involves me.
From your statement, Judge President, I would agree that there are advocates to accommodate the subject matters traversed in, especially in Gogo Matshiqisa's report, for the judiciary to embrace and accommodate and develop policy frameworks around those issues. And those issues cut across African cultures and religions. They extend to other cultures, Muslim, Jewish, and other cultures, that the judiciary should embrace such practices and have a policy framework around them. And if you are one of those advocates, and I know you to be one of those advocates, Deputy Judge President Mngqibisa, and what Gogo Matshiqisa is proposing, it's one thing to advocate, it's another thing for people living the reality of stigmatization and embarrassment. So if they have not reached the level that advocates for embracing practices of culture across the board, we cannot blame them too much that they have not reached that stage. Do you agree with me?
Well, I think I'll agree with you in respect of saying perhaps a policy framework is necessary. In the normal course of things, there are things that arise divisionally that I say to judges, I'll raise this with the heads of courts to see what they are going to do with it. But I have issues with a judge who has a problem that affects how the judge does his work or her work. And then when formal steps are taken against that judge for not doing his or her work, then you start hearing that actually you need a policy framework because this is the reason why I can't do my work. Yes, you know, I like initiating things, and it's going to be a discussion that we should have at heads of court level to say the judiciary is becoming predominantly African, black. Is there a case to be made to adopt a policy framework? Yes.
Let us move then to the judge's failure to deliver. And would you accept, I believe as you have already embraced the two reports, that the conclusions of Judge N Mngqibisa-Thusi's state of mind in that period made it impossible for her to work optimally and to achieve the level of performance that is demanded of a judge.
I accept that. That's why I say we should not be here,
Yes.
isn't it?
Yes.
But the unfortunate part is these reports come now,
Yes.
when all the damage is done,
Yes.
yet the damage could have been prevented.
Yes. So, Judge Mngqibisa's fault, if I may term it that at this moment, is that she did not present to you or the DJP or through colleagues that she's closest to information which would have been sufficient to explain her failures to deliver at the time.
She was grossly misconducted. She grossly misconducted herself by continuing to suffer a condition that was preventing her to work and failed to let the powers that be to say, I have a problem. That's why I can't do this. I need assistance. I think that's what I have a problem with, Judge Malindi. That's why I said in the morning, we should not be here.
Thank you, Judge President. Now, at the other level of your evidence is just a question of how this thing unfolded to the stage where we are, a stage where this tribunal should not have been.
Yes.
Thank you. Judge President, I would like to go to the consolidated list of relevant judgments when they were reserved and when they were delivered.
Do you want our list?
No. And those are contained in your bundle, JP.
This one.
Yes. The bundle is not paginated, but it's a document right at the end of the bundle.
The one that has Part A and Part B?
And Part B.
Yes.
This document shows that the judgments that are of concern in these proceedings are no longer outstanding, save for the fact that it demonstrates the point that those, to the extent that judgments were outstanding, it was for inordinately long periods.
Yes, I mean, Judge N has delivered all the judgments.
And Judge Mngqibisa-Thusi has endeavored to find statistics of her judgments from 2021 to June 2023, when she was suspended. She has not been successful in that endeavor, but my instructions are that her performance has been as exemplary as it was before 2017 in terms of delivery of judgments. You may be able to comment on that because you receive statistics regularly.
Well, I mentioned earlier in my evidence in chief that even though this tribunal is only concerned with the judgments that are set out in my letter, but this problem is a problem I confronted with soon after I took up leadership of the division in 2013. I referred to a number of judgments, and there's correspondence. She's aware of it that I've sent to her, right? So when you say as exemplary, I don't know what you mean. I want to make that point that I'm not sure that I agree that she was as exemplary, because if there's a judge who's constantly on your long outstanding reserve judgment list, that's not exemplary. That's her position. 2014, 2015, 2016, the letters are there. So I'm talking about it because that's what I see. But let me say the following. I said Judge Mngqibisa-Thusi is in the top 10. You are in the division. You know what I mean when I say it's in the top 10. The top 10 are the most senior judges in the division. If I were to compare Judge Mngqibisa-Thusi's performance from whatever period with someone who is her junior, who never spent time in crime, it will demonstrate the point I'm making to you, that she was not exemplary. Because I've had junior people, some are now in the SCA, who were appointed after her, who didn't spend time in crime, who were in civil. That means they were always on the receiving end of heavy workloads. But they were never in my reserve judgment, long outstanding reserve judgment list. So that's why I'm questioning this exemplary tag that you're putting on her.
I will go back to that, JP.
Yes.
But the tribunal here is concerned with a period 17 November 2017.
Yes.
With a judgment outstanding for 27 months. The period goes down to about 2020 of undelivered judgments. So that's the period relevant.
Should I confine my answer to that period?
Not necessarily.
I can.
This
Yes.
process
Yes.
does not apply those strict rules.
Yes.
But as a matter of fact, in this process, we are concerned with November 2017 going forward.
Yes.
Yes. And with the statistics at your disposal, which I say Judge Mngqibisa-Thusi is unable to access at the moment, my instructions are that 2022 has not been a bad period as the period relevant to this complaint that she's been delivering judgments.
Only 2022.
2022 post-2017.
Only 2022 or 2017 to 2022?
No. 2022 to June 2023.
That's fine. I think I'll concede to that, yes.
Yes.
But with that rider, that she's one senior judge who spent most of her time in crime.
Yes.
So she would not have had the same heavy work allocations as other people who were her peers, even in 2022.
Yeah. So if in 2022 she is out of that period of 2017 to 2021, and the experts say in their assessment she has nearly overcome the burdens and conditions that made her dysfunctional. That would be a sign that she's getting out of that period of debilitating conditions that rendered her unable to deliver.
What is the question, Judge Mandindi?
Do you accept that her performance in 2022 to June 2023 is an indication that with the help that she's receiving from the two experts, she is no longer suffering debilitating conditions that made her unable to deliver 2017 to 2021?
Yes, I'll readily concede to that. I mean, they say so, that's what they are seeing.
And JP, in a bundle, I don't know if it has a name.
It's our supplementary bundle. It's the respondent judge's supplementary.
If it's before you and the tribunal, it's headed Respondent Supplementary Bundle.
I don't have it with me. I've seen it. In fact, I've seen some of the documents in it. Thank you, Mr. Tan.
On page 1 to 5, if you have it, JP. JP, if you look at pages 1, 2, 3, 4, it is a list of other judgments that are my instructions are that Judge N Mngqibisa-Thusi delivered in the period 2017 to 2020. And I don't believe that there are duplications with the other list that we have traversed so far of delivered judgments. And if that is so, if there are no duplicates, this will be additional judgments that she delivered between 2017 and 2020. Do you accept that?
Yes.
Yes. And then on page 5 is a list of judgments of hers that were taken to the Supreme Court of Appeal and one to the Constitutional Court and survived, one partially. This would be in line with your view that, like in the Group 5 judgment that we testified about, she does produce good work when she does produce it.
When Judge N Mngqibisa-Thusi writes, she writes good judgments.
When you were testifying JP about the statistics regarding Judge Mngqibisa-Thusi in your own bundle. Excuse me. From page 1 in particular, the illustrations with the pie charts, you prefaced your statement by saying that people think criminal court is an easy court, but it isn't. Am I correct in recollecting
Yes.
your evidence?
That's correct, yeah.
Yes. Why is it not an easy court?
Because there are a lot of constitutional issues involved in criminal trials. And a judge has to, I like saying, it's a constitutional law minefield to run a criminal trial in South Africa, because you've got to watch your step. That's to step on a constitutional law mine that blows up in your face. You know?
And the fact that, for example, Judge Mngqibisa-Thusi was in the criminal court for 53% of her allocations does not necessarily mean that she was in an easy court.
No, but you remember I qualified it.
Yes, I
Yes.
Yes. And what is the division's policy on matters that postpone or collapse or for one or another reason do not continue in relation to the deployment of the judge involved in such a matter?
In criminal trials, we don't interfere. The policy is in civil trials. If you are involved in a 5-week trial that collapses on day 1, you have to advise the DJP that my trial has collapsed. You have other work for me. But in criminal trials, we don't. That's why I said other colleagues want to be deployed there, because they know that with the extra time at their disposal, when their trials don't run, they are able to catch up on outstanding work.
And other judges who are more conscientious, even if a matter in a criminal trial postpones, they would inform you and they will offer to be deployed if necessary.
Not necessarily, because the way the criminal trial role is planned, we've got stopper cases, because there's always a backlog of criminal trials that are waiting judicial attention, but not there yet because of the limited number of judges available to hear them. So if a trial collapses on day 1, the stopper is then given to that judge to deal with. And if it runs, it runs. Sometimes you find that the stopper doesn't run, but if the stopper runs, then that's it. If the stopper doesn't run, it's not the divisional policy to say that judge must tell us that their trial has collapsed, they've got nothing to do.
to sit in the proposed motion court to have a condition of clearance?
It could have happened, but that would have been a week's allocation in opposed because we were running short. Yes. It could have happened, I'm not disputing it. She was involved in a case that she called the ATM bombing case. It really frustrated her because it was refusing to end, you know. And I think we would talk in the context of that case, say, JPA, don't be disappointed, I'm not finished, and these are the reasons. I need another term or I need more time to do this case. I don't know whether that's the case or whatever, I don't know.
When a judge is sitting in the criminal court and there are postponements, gaps may be filled in by, stopper cases.
Stopper cases or bail appeals, you know. It's just to ensure that the judge is not totally idle, you know.
Looking at the statistics relating to Judge N Mngqibisa, by the JP, would I be correct to say your evidence is that in relation to the statistics in relation to Judge N Mngqibisa-Thusi JP, will I be correct that your evidence is that these allocations are normal and in some instances lighter than what other judges would do during certain terms, but that generally Gauteng Division carries back-breaking judicial functions?
Yes, yes.
So the statistics regarding Judge N Mngqibisa-Thusi should not be read to mean that she had the lightest of work in the division. This would be heavy on any ordinary judge in the division.
No, but I qualified that, Judge Malindi said she's a senior judge. Senior judges carry more work than junior judges. But she spent more time in criminal trials, so she would not have had the heavy work allocations that similarly placed and similarly experienced judges would have carried. That's what I said.
And just to close off on this one,
Yes.
criminal trials, the criminal court is not necessarily light work in the context of stopper cases coming in, and sometimes more conscientious judges are letting you and you allocating them other work. Am I correct?
No, you're correct. I mean, look, factor in the fact that when you're sitting in criminal trials, you don't pick up reserve judgments every day. You could sit for a whole month without picking up a reserve judgment. So those judges who are not in that work allocation are busy picking up reserve judgments when you're not.
Okay.
Just put your mic on again.
If I may go back to Judge N Mngqibisa-Thusi's period as a judge, you know, or you agree that she's a graduate of the Aspirant Women Judges Program, I think of 2008, and then was then appointed in 2009.
Yes.
Yes. And that she had served for some 7 or 8 years before 2017, when her real troubles started.
Yes.
President, there's one aspect in which I can't take instructions while sitting here. May we be excused for 5 minutes just to take instructions on one aspect? 5 minutes. Or we may be excused and come back after 5 minutes.
Sorry, I forgot. We will adjourn for 5 minutes to allow Mr. Malendi or Judge Malendi to consult with Justice N-Mngqibisa-Thusi, and then we'll be back after 5 minutes.
Thank you,
I'm
President.
sure strictly 5 minutes.
Strictly 5 minutes.
Okay, thank you. Judge Malendi, are you ready to proceed?
I am, President.
Okay.
Thank you. Judge President, it seems like we may conclude by saying that had this matter been presented to you in the manner that Judge N Mngqibisa-Thusi has done before this tribunal, this process would not have been necessary because you would have embraced the problems that she was going through and you would have devised a plan as head of court to alleviate her situation.
Yes, I would have done that because I've done that with everyone else who's approached me, yes.
Yes. And then finally, that her failures to deliver the judgments that are a subject of complaint was due to the conditions that she was suffering as stated in the two reports by the experts.
As I said, I'm in no position to dispute what those experts said, but I think I go back to what I said, that if you have a problem and you sit on it, that's not what you expect of a responsible judge, do you? Because you affect litigants in the division.
Thank you, President. That is the conclusion of our questioning of the JP.
All right, thank you, Judge Malendi. Judge Davis?
Yes, I'd like to just ask a couple of questions, if I may, Judge President. You've given statistics of respondent. I'm just interested, when you say heavy loads, I mean, how does this sort of load compare to other judges in the division?
I think, as I said, J.P. Davis, as a senior judge, this is a very light load compared to other judges at her level who had far onerous workloads because they were not in the criminal trial court.
And then I wonder if I can just follow up. I really would like your assistance on this because, I mean, you're a very experienced Judge President and you might be able to help. How does one sort of distinguish between misconduct in the case of dilatory judgments and gross misconduct? Here's the point. You know, if you find gross misconduct in a case, you might find that 30% of the judges of this country are going to be before the JSC within 3 minutes. I mean, how, you know, what I'm trying to do, can you help me here as to how one pigeonholes this?
I say it's gross misconduct here because, to start with, some of the judgments were reserved for very long periods. That's one. Two is you are unable to deliver. You know why you are unable to deliver, yet you're not initiating any corrective action. That's what makes it gross. You could distinguish with a period where a judge says, can you not allocate me 2 opposed motion weeks next term because I've got a backlog of reserved judgments. If you give me those weeks, it will add to my backlog. Someone who engages you as head of court I think that lessens the gravity of someone who fails when they engage and take you into their confidence and tell you what's happening. Okay. So if you simply take too long, in the main, you're not responsive to communication from the Judge President who says, hey, I've received this communication from the parties. They want their judgment. It's been outstanding for 9 months. When can I expect you to hand it down? And you ignore those things. Those are the factors that, to me, add to it being gross.
And then my final question, thank you. Sorry, have I interrupted you with?
No, I'm done. Thank you.
Can I ask finally, was it possible that that in this case, some conversation might have taken place with your deputies?
I've said she spoke to DJ Pilidwaba.
Yeah.
That's the one I know, because DJ Pilidwaba spoke to me in our divisional leadership meetings, that Judge N Mngqibisa-Thusi approached him with the possibility of a medical boarding. And he advised her that that's based on medical evidence. And that was the last we heard of that.
There was no further exchange?
No, there was nothing.
Thank you very much.
No, okay. Judge President, there are few issues that I would like to have clarity on. To start with, I may be wrong. It seems to me that generally in the judiciary, it is considered that when a judge has not complied with the norms and standards, that would constitute misconduct. Am I wrong?
It's, well, let me put my own interpretation of it. The norms and standards are just that, norms and standards.
It's an aspiration.
Aspirational. We aspire towards those norms.
Okay.
A document that applies is the Judicial Code, because that one is a binding document, right? Yeah. So my answer to yourself, President, is norms and standards are aspirational norms. But we use them as the standards that we trace as heads of courts to say, this judgment is now too outstanding. This is now too outstanding.
I'm glad that you have clarified that, because you may remember that in June this year, the Chief Justice circulated a memorandum to the Judges President.
Yes.
And he touched on that issue specifically, that if judgments are outstanding, it can only be misconduct if it breaches Article 10 of the Judicial Conduct.
Yes.
Okay. And I understand your complaint to be consistent with that. That is on page 2, the last paragraph of your affidavit on page 2, which says, it is my considered view that Judge N Mngqibisa-Thusi has committed the conduct referred to in section 14A, I think section 14.4A, and or B of the Judicial Service Commission Act of 1994. And when we go to that section, section 14.4A deals with impeachable misconduct.
Yes.
The ones that are listed in section 177 of the Constitution.
Yes.
And B deals with willful or grossly negligent breach of the code.
Yes.
So that is how you couched your complaint.
Yes.
But somewhere along the line, the matter came before the JCC. And the JCC, in its ruling, relied on the norms and standards, which differs from what was put as a complaint. What should we make of that? Because these proceedings are a consequence of the recommendation of the JCC. Without that recommendation, the tribunal would not have been established, and we wouldn't be here. Now, I just want to know, help me to understand if that is a problem or it's not really a problem. I'm just worrying about something that is not a problem. Because I looked at your complaint and I looked at the ruling by the JCC, and I saw that they went into detail, basing their decision on the norms and standards. Should I not be worried about that?
Well, I'll give you an answer that's fashioned by my years as a trade union lawyer. I lost many cases on technical points. That sounds like a very technical approach to things. I don't think it's a problem. The complaint was, as you read it, Mr. President, and how the JSCC characterized it, I'm not sure that it should be neither here nor there. The fact is we have evidence in front of you that I've told you why I had to lay a complaint, because it prejudices the division, it prejudices litigants. So that the JCC based their ruling on the norms and standards, as I say, is neither here nor there.
Okay.
Maybe that's a simplistic view, I don't know, but I don't think you should be worried.
Well, no, I'm happy I have an answer, because I don't know what to make of it. But that is a smaller problem. My bigger problem is this. Can I ask you to turn to page 67 of, and I'm not quite sure whether you have the old file or the new file. I'm using the old file. The ruling of the JCC starts at page 63 on my file.
Page 63. Thank you. I've got it.
You've got it. Let's go to page 67, specifically paragraph 12. This is the majority. And remember, we had a split in the middle here. There were 4 members of the JCC, and the majority was determined only by a casting vote.
Yes.
So in paragraph 12, they say, in this case, there does not appear to be any contestation about the veracity of the allegations on which the complaint is based. Judge N Mngqibisa-Thusi proffered an explanation for this turn of events. It does appear that the complaint, if established, will indicate incapacity or gross incompetence. The delicate function of investigating the cause fully and in any ameliorating aspect can only be properly investigated by a tribunal, given the seriousness of the matter. So that is the only paragraph, as I read their ruling, which indicates which grounds of impeachment in section 177 may be established. And it appears to me then that in their consideration, that is the JCC, they thought it's only two of those grounds, the ground of incapacity and gross incompetence. They did not include gross misconduct.
Apologies, Justice Jafta. Just which page are you referencing, sir? I'm still catching up.
67.
67 of the paginated records, or the
Yes.
previous records.
Yes.
Thank you, sir.
Yes. Now, again, I would seek your help. My understanding of the scheme of the Act is that for a tribunal to be established, there must be a recommendation by the JCC. And if the tribunal is established as a result of that recommendation, one has to go by what was recommended, unless the JSC says we accept the findings of the tribunal and its recommendation, but we want to expand the scope of investigation. If they so wish, they can do that. But it appears from the Act that if they do that, they are required to follow a certain procedure of giving notice to the parties and expecting representations to be made. Now, here, that did not happen. The JSC simply accepted the recommendation as made. But instead of confining itself to the grounds recommended by the JCC, the JSC added the one of gross misconduct. So that concerns me as a matter of law, whether that is permissible. I don't know whether it makes sense.
No, you are making sense. I'm following you, Mr. President. Yes.
Okay. So I just want to know whether, in terms of the law, it seems to me then that if the JSC says, I accept this recommendation as is, and it doesn't add anything, it doesn't say, well, we're going to add something else and then we will follow the procedure that is required by the Act. They can't simply expand the scope of the investigation to beyond the grounds identified by the JCC. Because remember, in terms of the Act, you can't go to a tribunal without having a recommendation from the JCC. Even in cases where there would be an inquiry in terms of Section 17, if the presiding officer in the inquiry reaches a conclusion that, in fact, what was committed there amounts to impeachable misconduct, the Act requires them to send the matter to the JCC for it to recommend to the JSC that a tribunal be established. So I'm really battling insofar as the law is concerned there, where the JSC simply expanded the scope of the investigation beyond the one that was set by the JCC. Would you have any comment on that?
I think, Mr. President, thanks for that. As for the legalities, I think the two legal teams will have to assist the tribunal as to what should be the issue. My own take of it is the JSC probably, in fact, even this ruling that Mr. President is reading from, I mean, the last sentence says, the recommendation says investigate the complaint. And
Yes.
the complaint wasn't what's in 12 only. It was more than that.
Yes, no, I understand that.
Yes.
But remember, when the JCC does that, it acts in terms of Section 16.4 of the Act.
16.4b, I think that's what they say.
Yeah,
That's all it did.
yes. So you see, Section 15.4 says, at the meeting referred to in subsection 2, the committee must consider Section 16.4 of the Act.
Section, sorry.
Yes, yes, of the Act. The Act, I'm sorry.
Sorry.
You've got it?
Yeah, yeah.
Oh, okay. JP, I'm not sure whether you have the copy of the Act.
No, I don't have it.
You don't have it?
Six, 267.
It would be on page 281, starting on page 281.
Yeah, I've got it.
Okay.
Thank you. I don't have this.
It says, at the meeting referred to in subsection 2, the committee must consider whether the complaint, if established, will prima facie indicate incapacity, gross incompetence, or gross misconduct by the respondent, whereupon the committee may recommend to the commission that the complaint should be investigated by a tribunal. So the committee is required to evaluate the complaint and determine which of the three grounds, or even if it's all, three grounds that are going to be proved if the complaint is established. And the recommendation arises from that because there are two options. The A says refer it to a Section 17 inquiry if it does not rise up to an impeachable misconduct. To me, it becomes clear then that the committee has to apply its mind, assess the complaint, and say which of the grounds are likely to be established. Once it has reached that conclusion, then it makes a recommendation. In that context, I have some difficulty then with moving away from the grounds that the committee has identified as those that might be proved by the complaint if established. But again, I think it's a matter that the lawyers are going to help us with. It's a matter that you would not have reflected on. I'm mentioning it so that we can get some help either from you or the lawyers, because it concerns me as to the scope of this inquiry. Is it an inquiry limited to what was recommended, or is it an inquiry open to what the JSC has said? Because the JSC, in the terms of reference, includes all three grounds, including gross misconduct.
I've not reflected on this issue, Mr. President, and as I say, to me, I'm not sure if one can constrain what's said in 12, or what's said in 13 with what's said in 12, but you're probably correct that they say it does appear that the complaint, if established, will indicate incapacity or gross incompetence. And then they go on and say, in terms of 16.4b, they recommend that the complaint be investigated by a tribunal.
Yes.
So I've not reflected on it. I don't think I can afford assistance.
You would accept that if the JCC's majority ruling is correct, is essentially what frames this dispute.
I think that's what Justice Jafta
Yes,
is
if
saying.
that's correct, then we only have to worry about incapacity or gross incompetence.
Yes.
Yeah.
Yes.
Okay. JP, that would be insofar as the first part of your complaint, isn't it? As I understand it, your complaint is framed in two grounds.
Two parts, yeah.
If we move past the first ground, which relates to impeachment, then we would be in the arena of non-impeachable misconduct, isn't it? Because you say in your complaint, the delay in the delivery of those judgments constituted a breach of the code.
Yes.
And the code in Article 10 says judges must deliver judgments within a term in which the matter were completed, unless the matter was heard in the last 2 weeks of the term, or the matter is complex, or there are other reasons for the delay. And if there are other reasons for the delay, the Judge President must be approached, and he or she should consent to the longer reservation of the judgment. So if one looks at Article 10, one sees then that these judgments were not delivered in the next term. They were not delivered first in the term in which the matter was completed. They were not delivered in the next term, which the article requires. And therefore, that would speak to your alternative complaint. But we only get there if we don't succeed on the first ground. And on the first ground, we're looking at incapacity and gross incompetence. Okay. And as I understand the evidence, Okay, let me put this to you. And you'll appreciate, Judge President, that the problems that we have in here is because I'm not aware, and you can tell me if I'm wrong, I'm not aware of a matter where a judge has been impeached successfully for failing to deliver judgments.
It's never happened.
It has never happened. So we have to be cautious in addressing the matter. Now, dealing with incapacity, my understanding of it is that Section 177 of the Constitution envisages a permanent incapacity of body or mind that disables a judge from performing their judicial functions.
Yes.
Okay. Now, if that is the definition of incapacity that we're dealing with, it seems to me here, yes, there was a failure to deliver judgments, but some reason was given for that, and when that reason or condition was attended to, there was improvement and judgments were delivered. Can we say in the present matter we have a permanent incapacity of mind or body that disabled Judge Mngqibisa-Thusi from performing her judicial functions?
I'm not saying that. And I think her experts are saying something else. So,
I know, and you'd appreciate because we have identified the issues. I just want to get clarity. It doesn't seem that we have that kind of evidence with that understanding of what incapacity means.
yes.
The difficult one then is of gross misconduct. It seems to me, again, and I may be wrong, and JP, if you haven't reflected on these issues, I would understand. What bothered me was we don't have precedent, and therefore one has to find a way how to deal with these things. It seems to me again that if one interprets gross misconduct in Section 177, it must be an interpretation that strikes a balance between the independence of the judiciary as an institution and the removal of judges who are on the bench, who should not be on the bench for a longer period. So it must be the type of incompetence that warrants
Misconduct.
no, incompetence. Remember misconduct, we said misconduct for the time being. It's not within.
Yes, but I thought now you'd gone beyond incompetence.
No, I'm talking about...
You're unpacking what misconduct is.
Did I say misconduct?
Yes.
No, I was wrong.
You
No. Pardon me. Pardon me. I'm still speaking about incompetence.
Yes.
It must be incompetence of the nature that warrants the judge to be removed. Now, can we say that we have that kind of incompetence here? You have spoken favorably of Judge Mngqibisa-Thusi, that she writes beautiful judgments. The only problem that we have is the delay.
Yes.
That's the only problem. Can we say then that that constitutes the kind of gross incompetence envisaged in Section 177 of the Constitution? That's what I'm battling
Yes.
with in my mind. I have no answer to it as yet. That's why I'm putting it to you.
A failure to deliver judgments in itself can amount to incompetence, isn't it? Because it means you are not competent
Yes.
to, right? And if it's over an ongoing period, like, Judge Malindi constrained me to the terms of reference of this, even though as head of court I say it started some time ago,
Yes.
right? So I would say if that fits within what was identified by the JCC,
Yes.
then I don't see any problem in the matter being resolved on that basis. Because even though you may look at 2017 to 2020, 2021, and we using 2022 as an example, I'm not sure that one can safely conclude that the problem ended when the spirituality route was firmly engaged. I'm not sure if one can say that. It's too short a period. Okay. So I didn't reflect on these issues. I just said, I'll just come and say what motivated me to make the complaint.
No, I know. You
And,
came to testify on the facts.
Yeah, on the facts.
Yes.
So as to the legalities of it, we've got a number of legal eagles in this room, one on one side and 4 on the other side. So that should be enough to assist the tribunal. But I can't take it any further, Justice Jafta.
Yes. And it seems to me that this process pains you.
It does.
Even though on a number of occasions, I think many of judges have breached Article 10 of the code, you have not reported them.
That's true. The Judge Mngqibisa's team yesterday added last year's reserve judgment list. There's a judge in that list who's now been boarded medically and I didn't file a complaint because when I went deep into the issues, I realized that the problems were insurmountable.
Yes.
And I said, well, consult medically because clearly there's a problem here. And the medical evidence came to me to say he can't continue here. Mm-hmm. That's why I recommended for him to be. But I would have reported him. So it's not a robotic reaction from me. Yes. I don't report everyone. Yes. In fact, if we applied the code in the terms you read, Justice Jafta, we would be every day disciplining judges because the code is completely outdated, right? So that's all I can offer to say. I don't report anyone, but I engage with people, and people, if they are responsive and they agree to take corrective action, then I don't touch the JSC process. In fact, as the CJ said in his letter that you referred to, he said those judge presidents who don't report judges, he will take action against them. I'm prepared to take that. If I'm going to be able to say, CJ, you can discipline me, but these are the facts, and this is why I didn't report this particular judge. Right. So I thought they would take me through that report because I would explain to them that you may find some judge who's alleged to have reserved a judge for 38 weeks, which is not correct, by the way. But there have been processes in place, and he's now out. So litigants are safe from him, if I may use that terminology.
And as I understand, your evidence is that the so-called 3-month standard,
Yes,
it's inappropriate for divisions like yours.
yes.
It might be suitable for Northwest Division.
Don't say it aloud, because they'll be very angry.
or Northern Cape Division. Not those that are big and where the workloads are too high.
Yes, yes.
And to apply the one-size-fits-all approach, it's not appropriate.
No.
So it's something that the judiciary itself has to look into. But it seems again that on the other end of the scale, we have a serious problem of reserved judgments that are not delivered.
Oh, that's a big problem.
And that too must
Yes.
be addressed.
Yes, that's a big problem.
All right.
It's a big problem, and it's high time that judges who don't deliver judgments must feel the pinch. It's high time, because it's gone on for long enough, right? So as you say, Justice Jafta, that also must be considered.
All right. Thank you, JP. Yes.
The follow-up exchange that you had with Justice Jafta, do I then understand, let's assume for the purpose of debate, certainly I need to think this through as to whether a JCC finding is binding on the ultimate body that makes the decision, or whether in fact gross misconduct can be added to the charge. But let's leave that aside. Is your case effectively here, given the distinctions that have been drawn between 3 months, 6 months, lots of judgments, is it that there's a consistent pattern here? I don't want to put words in your mouth. I'm trying to just understand, in a sense, the gravamen of your factual complaint. Is it, when you look at all these cases, number one, there's a consistent pattern of lateness and a failure to engage with the leadership of the court, notwithstanding the inquiries that were made in this regard?
I think I've been saying that.
I just want to make sure that's
Yes.
what it's about.
Yes.
And on that line of argument, you would say that's why you registered the complaint as being one of those
Yes.
three categories.
Yes.
Okay.
That's the point. In fact,
Okay.
as the evidence leader, when he was leading me, to say in my, when I followed up and actually started mentioning other cases, to say it's a pattern, right, that I've seen from this judge, that it's norm that she reserves for inordinately long periods. So that's my case.
Thank you.
Whether it amounts to gross incompetence, gross misconduct, that's for you to decide.
Judge Malendi, I would allow you, if you have just a few, very few. This is an indulgence. You don't have a right to put to the Judge President arising to the debate that he has had with Justice Davis and myself before we allow Mr. Mop to re-examine if he so wishes.
Thank you very much, President. JP, of course, the question of incompetence will be a subject for argument at some stage.
Yes.
But do you agree that incompetence goes more to intellectual ability or inability?
I don't think so. Even people who write very well, I mean, can be incompetent by simply because they want to write doctoral theses in all their judgments. Take a long time, all the time, to write those judgments. That's incompetence.
The question of medical boarding arose. I tried to avoid the issue, but Judge N Mngqibisa-Thusi says Judge DJ Pilitwaba approached her and indicated that he's become aware of her difficulties and recommended medical boarding to her, which she did not accept. As it's the case, she's going through this process without having followed the route of medical boarding. I just wanted to say that, and you may comment on it if you wish.
Well, my evidence is clear. When what he told me, it was the other way around.
Yes.
But I'm sorry, Mr. Judge Malindi, does that arise from the exchange that, remember I said I'm giving you an indulgence.
Yes.
And that indulgence is limited to what arose from the debate that the Judge President had with me and Justice Davis. Now you get into something else.
I believe that it was traversed, but I apologize if
Okay.
I overreached.
Okay.
The last one is the Chief Justice statistics, which the JP referred to.
Did that arise as well from the debate? I didn't talk about the statistics, and I don't remember Justice Davis did.
The JP referred to them and said we included them in our bundle,
Who?
the respondents.
No. Remember, we are at the stage where you seek clarification
Yes.
on issues that you did not anticipate,
Yes.
which arose from the debate that the Judge President had with us.
Yes.
So it can't be something that you recall, which you should have raised earlier on, but you had forgotten. It can't be.
Thank you for the advocacy training, Justice Jafta. The one on incompetence was my only question then in this context.
Thank you, Judge Malindi. Mr. Mop, it's your witness. Would you like to re-examine him?
Just on one aspect, Chairperson, and not on any other questions by the tribunal members itself. JP, just one issue. Judge Malindi touched on Gogo Mashikwe's statement that if there had been a policy, it would have been beneficial. I'm paraphrasing now. And the sense conveyed in that engagement was that had there been a policy, Judge N Mngqibisa-Thusi would have been free to disclose. That was the context within which that arose. Now, you did deal with that issue by saying it didn't absolve individual responsibility, the lack of a policy. But in that context of existing policies, because there are two expert reports that have been filed by the respondents' team. Now, insofar as the conditions identified by the second expert, are there policies in place that regulate those conditions? The second expert by the respondent, not Gogo Mashikwe.
No, there are no policies. It's still based on what I said, that if a judge has an issue, right, and we have a medical aid scheme, and that if a judge has an issue and the judge doesn't want to disclose whatever issue it is that's afflicting that judge is welcome to engage that medical aid scheme that has several components, right, that are geared towards responding to what the problems would be. But there's no policy. It's a medical aid scheme that all judges belong to.
Maybe I should ask the question differently. Is there a sick leave policy that regulates judges?
Yes. You can say it's a policy, but judges are entitled to sick leave. Let me put it that way. And it is also activated by a judge saying, I fractured my femur, like one who tried to paint his roof and fell. And he was going to be disabled to work for a whole term. I get that medical certificate. I recommend that he be given sick leave for the whole period. So you can call it policy or whatever. And let me just go back to what Gogo Machiko is saying. It's Gogo Machiko saying that. It's not Judge Mngqibisa-Thusi. And Judge Mngqibisa-Thusi had the opportunity to say that a long time ago. She didn't. So Gogo Machiko is expressing an opinion to say the judiciary failed her. And I take issue with that. We didn't fail anyone. So the issue of the existence of policies or whatever doesn't absolve anyone from activating processes through the right channels wherever they are to make sure they get assistance.
Thank you. I have no further questions.
Thank you, Mr. Mob. Thank you, Judge President. You are excused, and thank you for coming to testify.
Thank you, Justice Jafta. Am I expected to be here for the duration of the sitting?
No, unless you want to be.
Oh, thank you.
If we need you, we will seek you where you are.
Okay. Thank you very much.
Thank you.
Thank you. And good luck.
Thank you, we need it. Mr. Mob?
Chairperson, that concludes the evidence that I intend to present. I anticipate the issues that you raised as the tribunal are legal issues which will be dealt with by legal argument, not necessarily by witnesses.
Yes.
So that concludes the evidence on my part then.
All right.
Thank you, sir.
Judge Malendi?
President, it is 3:30. It might be convenient that we reconvene tomorrow morning so that we carry the, well, first I start with an opening address and then call the first witness who will be the respondent herself.
All right, thank you. All right, we will adjourn and resume tomorrow morning at 10. May I remind the media about the ruling? If tomorrow morning we're starting with Judge Mngqibisa-Thusi, my ruling will stand that the hearing would be in private. Thank you. We adjourn.